Welcome to today's deep dive. Whether you are prepping for a meeting, catching up on the legal field, or, just insanely curious, you are in exactly the right place.
Yeah, absolutely. Thanks for having me.
So today we have a very specific mission. We are going to explore the rapidly shifting landscape of the Canadian legal profession.
Right.
And we're doing this entirely through the lens of a newly published March 2026 report. It's by the nonprofit Ask AI, and it's called The Guide: Artificial Intelligence in Canadian Law Firms.
And honestly, it is a phenomenal data set to dig into. Ask AI has been tracking workplace tech for years, but they've zeroed in on the Canadian legal sector right now because, well, the changes happening there are just structural.
Totally. It's not just a software update.
Exactly. It's a fundamental rewiring of how law is practiced, how these firms are structured economically, and honestly, how young lawyers build their actual careers.
Right. And to set the stage for you, the listener, I want to start with a statistic from the guide that honestly made me do a double take.
Oh, I know the one.
Yeah, you know it. According to the data, 80% of Canadian law firms with over 20 lawyers are currently investigating or actively piloting generative AI.
80%.
80%. But here is the hook. A mere 7% have fully implemented it across multiple practice areas.
Yeah, that drop-off is wild.
Okay, let's unpack this, because that massive gap between, exploration and actual implementation matters so much, not just for the lawyers, but for you as a consumer of professional services.
It tells the story of an industry that knows a tidal wave is coming, right? But they're all still standing on the beach arguing over how to build the boat.
That's exactly it. And why is this AI invasion happening so aggressively right now?
It really comes down to a massive wave of market consolidation. The underlying tools are maturing at just breakneck speed, and that's driven by an influx of capital the legal sector hasn't really seen before.
We are seeing some mind-blowing market moves. In the guide, they mentioned Clio.
Yeah, Clio's already a massive player in legal practice management.
Right, and they recently acquired the global legal research company VLex for $1 billion. $1 billion.
Which is huge. The stated goal there is to combine raw case law directly with workflow automation.
And then you have Blue Jay Legal raising 167 million Canadian dollars to accelerate their AI-powered tax chatbot.
It's an absolute gold rush.
But let me push back on that for a second.
Sure.
Why the sudden explosion of capital right now? Because, let's be honest, the legal industry is notoriously slow to adopt anything new.
Oh, incredibly slow.
Yeah.
But we have to look at the competitive dynamics.
Mm-hmm.
The legacy platforms have had a monopoly on legal data for decades.
Right.
The guide features this brilliant quote from Lachlan Dion. He's a legal consultant writing in the CBA National magazine, and he perfectly captures this inertia.
What does he say?
He points out, Thomson Reuters and LexisNexis are lucrative and successful companies, and they don't have many reasons to change. But this Clio Vlex deal might be the disruption we need.
Wow. So the big legacy players are finally being forced to innovate.
Exactly, because these newly funded tech companies are building platforms that can actually synthesize and act on legal data. They aren't just forcing a lawyer to run a manual search anymore.
Which changes everything. I noticed the data in the report splits legal services into 3 distinct buckets now.
Yes, automatable, AI-assisted, and strategic.
Right. So how is that actually changing the billing model? Because if you look at that first bucket, the automatable commodity work like non-disclosure agreements, standard incorporations, basic wills.
Yeah, a $50 platform can now produce those in minutes.
Exactly. So doesn't that create immediate economic friction?
Oh, absolutely.
Yeah.
Historically, firms relied on this high-volume, routine work for steady revenue.
Right.
Kept the lights on. But clients are shifting their expectations.
Because they know the tech exists.
Right. If you're a corporate client, you're simply not going to pay traditional law firm hourly rates for a standard employment agreement that an AI just generated instantly. The market just won't bear it.
But wait, if a firm hands all that standard commodity work over to a machine, aren't they immediately killing their most reliable cash cow before they've even secured the higher level strategic work?
That is the exact fear keeping managing partners awake at night.
I bet.
But look at the alternative. And that brings us to the second category, the AI-assisted services. Firms must lean into the tech and own these workflows themselves.
So using tools like Clio's document automation?
Yes, to deliver those standard services faster and cheaper. Because if they refuse to cannibalize their own commodity billing, some lean tech startup will just do it for them.
And then the traditional firm loses that client relationship forever.
Exactly. What's fascinating here is that the firms clinging to the old commodity billing model are actively setting themselves up for obsolescence.
They have to burn the boats to survive.
They do. But the firms that automate those services effectively, they retain the client. And crucially, they free up their human lawyers for the third category.
The strategic work.
Right. Complex M&A advisory, cross-border transactions, earn-out negotiations, intricate litigation strategy.
Navigating highly nuanced regulatory environments.
Yes, this is what clients genuinely need a human brain for.
So you let the machine handle the standard privacy policies so the senior partner can focus entirely on the high-stakes corporate merger.
Exactly. It's a total shift in resource allocation.
Which naturally leads us into how the actual day-to-day operations of these firms are changing.
Oh, it's a massive operational shift.
You know, the best analogy I can think of for this is a law firm being like an antique, beautifully crafted mechanical clock.
Okay, like that.
For decades, it ran on perfectly fitted brass gears. You've got junior lawyers, paralegals, law librarians, all turning at a predictable pace. And now someone is trying to fit a digital motherboard right into the middle of those gears.
That is a highly accurate way to visualize it, because that digital motherboard isn't just affecting the lawyers, it's touching every single operational department.
Like marketing, for instance.
Right, take marketing. The guide highlights a massive shift in how prospective clients find legal help. Historically, a firm's website was its premier digital asset.
You had a legal problem? You did a traditional web search.
Right. Now, prospective clients are bypassing traditional searches entirely. They're turning to chatbots like ChatGPT or Gemini to ask complex legal questions.
So the marketing team suddenly have to figure out how to get their firm's brand and expertise recommended by an AI platform's underlying model.
Not just a search engine algorithm. It completely upends traditional SEO.
It's wild. And then you look at finance and billing. The traditional law firm billing process is famously painful.
Oh, tracking time in 6-minute increments.
Manually reviewing pre-bills, the inevitable client pushback, the write-offs.
It's a nightmare. But now, platforms like Clio are integrating AI to handle time entry predictively. They generate the invoice and collect the payment end-to-end.
Which just dramatically reduces the administrative bloat that eats into profit margins.
Exactly.
I'm looking at this section on IT and knowledge management, and the acronym RE keeps coming up.
Retrieval Augmented Generation.
Right. For those of us looking at the technical leap here, how is RE functionally different from just running a standard keyword search through a firm's document database?
Think of it this way. Instead of searching for the keyword indemnity clause and getting a list of 500 historical contracts that you then have to read manually,
Which takes hours.
days sometimes, RE allows a lawyer to ask the system a conversational question. You can ask, how did we negotiate the indemnity clause in the Smith merger last year compared to the Jones merger?
And the AI actually synthesizes the answer from both files.
It reads, compares, and generates a cohesive, cited response based strictly on the firm's proprietary history.
That's incredible.
These pipelines ingest unstructured case files, historical documents, even handwritten notes, and they create an instantly searchable institutional memory.
But the Ask AI guide is very clear that you can't just plug a generic consumer AI into a law firm's server to do this. There's a great quote here from Jack Newton, the CEO of Clio.
Oh, the one about the foundational model.
Yeah. He says, all of the foundational large language models are powerful, but their general purpose, trained on the open web, not on real legal data.
And that distinction is the difference between a helpful tool and a malpractice suit.
Right.
You need an AI that understands the specific nuances of Canadian jurisprudence, the hierarchy of courts, local procedural rules. An AI trained on Reddit and Wikipedia cannot draft a viable factum for the Ontario Superior Court.
Definitely not. Now, here's where it gets really interesting, though.
Okay.
We've talked about the software, the acquisitions, the firm operations. But what about the humans?
The junior lawyers.
Exactly. What about the articling students and the junior lawyers just starting out? Because the guide outlines what essentially amounts to the death of the traditional apprenticeship.
It really does.
Anyone who has survived articling knows the unique misery of sitting in a windowless basement at 2 a.m., reading thousands of emails about a corporate merger just to find one hidden liability.
The quintessential rite of passage.
The fact that a machine can now do that while I sleep is both a miracle and, honestly, a little offensive to my past trauma.
It's a rite of passage that is rapidly going extinct. but we have to look at the uncomfortable economic truth behind why that basement existed in the first place.
Right, the old model of legal training was built on a scarcity of processing power.
If a firm had 10,000 documents to review for a discovery phase, the only way to process them was to throw a small army of junior lawyers at the problem.
But billing out those junior lawyers at high hourly rates for low-value grunt work has historically been enormously profitable for the senior partners.
It was a core pillar of the traditional law firm business model.
So the friction isn't just about how to train the new kids, it's about partners losing their most reliable profit engine.
Exactly. Firms are being forced to abandon a highly profitable revenue stream. But as that low-value work gets absorbed by AI, the skills that actually matter for a successful modern lawyer are coming into sharp focus.
Because you simply cannot learn these skills from grinding through discovery documents in isolation.
No, you cannot learn how to read a room from a spreadsheet.
The guide lists the new core competencies. It's things like understanding what a client actually needs versus what they say they need.
Exercising judgment under intense pressure.
Building trust with stakeholders.
Navigating complex, multi-party negotiations, which means the training model has to flip entirely.
So if you are an articling student or a junior lawyer navigating this, the guide lays out a very specific new playbook for your career. The days of hiding in the library for 3 years to make partner are over.
Completely over. First, you need to push to shadow on real complex files very early in your career.
Like M&A or high-stakes litigation.
Exactly. You need to be in the room where the human judgment is actively happening.
And secondly, the guide suggests juniors should actually use AI aggressively to compress their own grunt work.
Yes. If you are handed a routine task, use the firm's approved tools to finish it in a fraction of the time.
And then use that saved time to explicitly ask for higher-level strategic work. You have to advocate for your own accelerated development.
The firms that move first on this, the ones that intentionally compress that low-value apprenticeship period, are going to develop better, more strategic senior lawyers much faster than their competitors.
It transforms talent development from a necessary administrative chore into a massive strategic advantage for the firm.
It really does.
So what does this all mean?
Well,
If you're a managing partner at a firm or part of a technology committee, how do you actually cross that massive gap from the 80% who are just poking around to the 7% who have actually implemented this stuff securely?
right, the practical steps. The Ask AI guide outlines 7 of them for firms.
Let's dig into how these actually play out on the ground. Starting with step 1, audit the shadows.
This is critical because the reality is someone at your firm is already using ChatGPT or another consumer AI tool secretly.
They're just trying to save time.
They are, but in doing so, they're creating a massive confidentiality risk. Law firms deal with highly sensitive privileged data. You have to run internal audits to bring that shadow usage out into the open so it can be managed.
Ignoring it is not a defense.
Not at all.
You definitely don't want a junior associate accidentally feeding details of an unannounced billion-dollar merger into a public AI model that then uses that data to answer someone else's prompt.
That would be a disaster.
Step 2 is about focus. Pick one closed, purpose-built tool. But getting a partnership of 50 lawyers to agree on one tool seems like an operational nightmare.
It is, which is why the guide advises against trying to boil the ocean.
Yeah.
Don't overhaul the entire firm's infrastructure at once.
Start small.
If you're a tax-focused firm, run a pilot program with BlueJay. If you do heavy litigation, pilot Co-Counsel Legal by Thomson Reuters.
Yep.
Get one definitive win on the board on secure infrastructure, prove the return on investment to the skeptical partners, and then expand.
Makes sense. Now, step 3 is a massive skills update. Prompting is the new Boolean. I think we can skip past the basics of what a prompt is, but the guide frames this as an urgent liability issue.
Because it is a liability issue.
Right.
Prompt engineering is entirely replacing Boolean search operators.
Right.
If a lawyer cannot construct a precise, context-rich prompt, they're going to trigger an LLM hallucination.
Where the AI just invents case law or misinterprets a statute.
And relying on a hallucination is an immediate malpractice risk. Prompting is no longer a niche tech skill for the IT department. It is a mandatory core professional competency for every practicing lawyer.
Which feeds perfectly into step 4, policy before sanctions. We are already seeing law societies and provincial courts issuing guidelines on AI usage. Firms need to clearly establish what client info can never be inputted, which tools are officially approved, and exactly how the output must be verified by a human before it ever goes to a client or a judge.
And those policies have to be tied to step 5, which is redefining billable targets.
Oh, right. Because if you give a junior associate an AI tool that allows them to draft a complex memo in 1 hour instead of 10, you cannot still expect them to hit a 2,000-hour annual billable target.
The math physically breaks. Firms have to restructure how they evaluate and reward productivity, moving away from time spent toward value delivered.
And rounding out the final steps, the guide emphasizes appointing an AI champion, someone who actually owns the rollout and is accountable for it.
And client communication.
Right. Corporate clients are increasingly demanding to know if AI is being used on their files, and they want the resulting cost savings passed down to them. Transparency isn't optional anymore.
If we connect this to the bigger picture, all of these steps, the audits, the policies, the restructuring of billables, are leading toward an ultimate goal for these firms.
And that goal is proprietary advantage.
Exactly. This is where the concept of the private cloud becomes the most crucial battleground for the future of the industry.
The guide details how platforms like Alexi Private Cloud allow firms to completely isolate their AI infrastructure.
Because the underlying fear for a lot of these legacy firms is, if I spend millions of dollars training an AI model on all my best contracts, my unique litigation strategies, and my historical wins, won't the AI company just use that aggregated data to make my direct competitors better?
That is the exact fear with public or shared models.
It flattens the competitive landscape. But with private cloud deployments, a firm keeps absolute isolated control of its data. Mark Doble, the CEO of Alexi, is quoted in the guide saying, "A law firm's proprietary AI is now a critical source of competitive advantage."
Firms can hoard their niche subject matter expertise, their local market contacts, their highly tuned workflows, and their proprietary legal knowledge within a secure, private AI stack that never speaks to the outside world.
They're essentially building a digital brain that is entirely unique to their firm. A brain that knows exactly how that specific firm wins cases and closes deals.
And because it's locked in a private cloud, it creates an insurmountable moat. If you are a mid-sized firm with a highly tuned private AI, you can punch way above your weight class against the national mega firms.
That is a totally different way of thinking about what a law firm actually owns. It shifts the entire value proposition of the firm.
Historically, a law firm's value was strictly the individual brains of the partners walking in and out of the elevator every day.
Now the value is shifting toward the collective, customized intelligence of the firm's proprietary technology stack.
So bringing this all together, the core message we are taking away from this Ask AI deep dive is that artificial intelligence is fundamentally restructuring the economics of Canadian legal practice.
Without a doubt.
It is aggressively stripping away the commodity work that used to be the bread and butter of traditional billing. It's completely rewiring firm operations, from how they market themselves to chatbots, to how they process invoices, to how they query their own history using RReg.
And, for better or worse, it is destroying the old, slow, grunt work-heavy path to partnership, forcing juniors to become strategic advisors on day one.
It's a textbook paradigm shift. The historical inertia that protected the industry is gone. The old rules of leverage and billing no longer apply.
And the new rules are quite literally being written in real time by the 7% of firms actually implementing this technology.
And that is why this matters to you. Whether you are a business owner paying legal bills and demanding more efficiency from your outside counsel, a junior lawyer trying to navigate a career path that is shifting beneath your feet, or just a tech enthusiast watching one of our oldest, most stubborn legacy industries transform before your eyes.
This shift profoundly affects how justice and business operate in Canada.
It absolutely does.
I'd like to leave you with one final thought to mull over as we wrap up today. We have talked extensively about how AI is absorbing all the routine grunt work that traditionally served as the training ground and profit center for new lawyers.
Right.
And we've seen how a firm's most valuable asset is rapidly transitioning from the individual experience of its partners to its proprietary custom-trained AI stack. So the provocative question is this: as that digital moat deepens, will the most successful law firms of the future look less like traditional legal partnerships and more like tech companies that just happen to practice law?
Wow. What a question to end on. Thank you for joining us on this step dive. Keep questioning, keep learning, and we will catch you next time.